So Lordship may take it up after some time. My senior is on legs.
Anyway, this is appeal only.
Appeal, first appeal.
Your name, please.
N Sultana.
Yes.
N Sultana. Just N Sultana.
Heard Miss N. Sultana, Learned Counsel for the appellant, and Mr. R. Kaushik, Learned additional public prosecutor for the respondent number 1, state. Full stop. This criminal appeal under section 415, within bracket 2, Paragraph Nagori, on 8 2023 is referred against a judgment in order dated 5/11/2024, passed by the Court of Learned Additional Session Judge cum Special Judge within bracket POCSO Sipsagar. In special POCSO bracket of case number 21 of 2023, arising out of Namti Police Station, case number 03 of 2023, by the judgment and order dated so and so, what's the special court code? The special court has found the appellant guilty of the offenses under section 506 and 370, section 376 within bracket 3, Indian Penal Code, read with section 6, POCSO Act. Full stop. In view of section 42 of the POCSO Act, the appellant has been sentenced under section 6 POCSO Act to undergo rigorous imprisonment for a period of 30 years and to pay a fine of rupees 30,000, in default of payment of fine, to undergo further rigorous imprisonment for a period of 6 months. Full stop. For the offense under section 506, the appellant has been sentenced to undergo imprisonment for 1 year and to pay a fine of rupees 5,000 in defaults of default. Full stop. The sentences are ordered to run concurrently. We have reduced the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case records of POCSO case number so and so, we call for issue notice returnable in 4 weeks as Mr. Kaushik has appeared extra copy. Practice direction. Service report in respect of respondent number 2 from the officer in charge, Namdi Police Station, on the reporter, returnable. This is the case of the police.
Please, in this case, LC are not received.
Heard Mr. N.M. Dr. Learned Counsel for Legal Counsel.
Yes.
Legal Counsel for the appellant and Ms. P. Bhuya, Learned Senior Counsel, Additional Public Prosecutor. Listed by Ms. R. Das, Learned Counsel for the respondent number 1, State of Assam. Respondent, State of Assam. In view of office note dated 26/3/2025, let a first reminder be issued for the trial court records. Lays the case after 4 weeks.
Miss Khatami, inform my learned friend, my lord, she is having some personal difficulty.
Okay, Ms. B. Bhuya, Learned Senior Counsel, an additional public prosecutor, preparing for the respondent status submitted that she has been requested by Ms. S. Khatami and Learned Legal Aid Counsel for the appellant to inform the court that Ms. Khatami has some personal difficulty today. Full stop. As the case records of Sessions case number TI/04/2021 have been received. Sorry. As the paper book is ready, raise the appeal for hearing in due course.
The case is ready for hearing.
M. Ahmed,
Yes, Lord, sir. Paper book has been
for
received.
the appellant. B. Bhuya, Senior Counsel and Additional Public Prosecutor, assisted by Ms. Arda Aslan and Counsel for Respondent number 1, State of Assam, and Ms. G. Borwal and Amai Green, representing the respondent number 2 are present. First of, as all the respondents are represented, and the paper book is ready, please to raise the appeal for hearing in due course.
Please, your lordship.
Yes, Mr. Prasad,
So,
53 days delay.
lordship.
Huh?
Lordship, my explanation, lordship will find at paragraph 11. Starts at page 7.
Order inadequate sentence.
Lordship, only 1 year's 3
What
months.
is the maximum and minimum? Is there any minimum?
It's a-
Under what section?
UAP.
UAP Act,
UAP. So it may be up to 10 years.
up to 10
Up
years.
to 10.
No minimum.
Fine can be given. Or
Convicted under section?
120B and 38 of the UAP.
UAP Act. Or is the impugn order otherwise in the appeal?
Lordship will find that at page 14. It starts at page 14 also.
Page. Final report. You have the order in the IA,
Not in the,
in the main appeal,
in the main appeal, lordship, page 14.
page 14.
Yes, lordship. And
Page.
the relevant portion, lordship will find at paragraph 17, page 19.
And they have been convicted under what section?
120B and,
We pleaded guilty.
and 38.
A4 was in incarceration for 2 months. Or 1 year, 2 months, 24 days.
Yes.
The
The
other
previous-
one is 1 year, 3 months, 1 day. Fine can also be imposed instead of sentence. Or fine. That hurt. Mr. R.K. Devchuri. You were standing counsel, Nia?
No, lordship, I'm appearing as the DG.
Okay. Let Deputy Solicitor General of India. For the appellant. National Investigation Agency, within bracket NIA. And Mr. B. Prasad,
Number one.
applicant. And Mr. B. Prasad, and counsel for the opposite party number 1 and 2. Full stop. And I counsel. NI. How it was filed in 2023?
Notices. That it's because they were out.
So no, could not be served.
Notice.
No instant application. And the first provision to subsection 5 of section 21 of the National Investigation Agency, Act 2008, read with section 5 of the Limitation Act 1960 is preferred, seeking condonation of delay of 53 days in filing the accompanying criminal appeal under section 21 of the NIA. 20. We need to make it one. Better. The applicant as the appellant has preferred the accompanying criminal appeal. Against an order dated 26/7/2023. Passed by the learned special judge, Nia, Guwahati, in special Nia case number 02/2020 in connection with RC-01/2022/NIA-CUW. Postal. In special NIA case number 02/2022, the opposite party is herein where arrayed as accused persons to stand the trial. First of all, the opposite party number 1 was namely Kumud Khulwai, Joe Elias, Joyce, or Suresh, Mr. Was A4, and opposite party number 2, namely so was A5. During the course of the trial or
During the course.
during the course of the trial,
Or should we find a
the learned special court framed a charge under section 120B, IPC, and Section 38 of the Unlawful Activities Union Bracket Prevention Act 1967 on 26/6/2023. Full stop. After framing the charges against both the opposite parties. Full stop. After framing the charges, both the opposite parties, that is A4 and A5. The charge was read over and explained to them on 9/7/2023. Full stop. On 9/7/2023, both the opposite parties as accused filed petitions pleading guilty to the above charges. Full stop. The London Special Court has accordingly convicted them on 26/7/2023. Imposing a sentence of simple imprisonment for 6 months each, and to pay a fine of ₹500 each, with default stipulation, for the offense under Section 120B, IPC. In respect of the charge under Section 38, UAPA Act, the opposite party number 2, A4, has been imposed a punishment of sentence of rigorous imprisonment for the period already undergone, and for the opposite party number 2, A5. The sentence was for rigorous imprisonment for the period already undergone. Full stop. In the order dated 26/7/2023, the Special Court has accorded that the accused, A4, was in incarceration for about 1 year, 2 months, and 24 days. And the accused, A5, was in incarceration for about 1 year, 3 months, 1 day. Post of para. Being agreed by and satisfied with the order dated 26/7/2023, the appellant, Nia, has preferred the accompanying petition. Post of para. With 53 days delay. Post of. As per subsection 5, as per subsection 5 of Section 21 of the NIA Act, every appeal shall be prepared within a period of 30 days from the date of the judgment, sentence or order appeal from. Full stop. The first proviso to subsection 5 of Section 21 has provided that the High Court may entertain an appeal after the expiry of the said period of 30 days, if it is satisfied that the appellant had sufficient cause for not preferring the appeal within the period of 30 days. We have gone through the statements and averments made in the instant interlocutory application, more particularly,
Goes to paragraph 11.
Paragraph 11. Thereof. We have also gone through the contents of the objection filed on behalf of the opposite parties. Comma, besides hearing the learned counsel for the parties. Full stop. Having gone through the statements and amendments made in the application, comma, more particularly, comma, paragraph 11, thereof, comma. We have to consider view that the appellant has explained the period of delay of 53 days showing sufficient cause. In preparing the accompanying criminal appeal with 53 days delay. Also. In the above view of the matter, comma, the instant application seeking condonation of delay of 53 days in preparing the accompanying appeal is allowed the registry to register a connected appeal and thereafter release the same accordingly.
It's a copy of the.
Let them come.
Item 6.
Records are received.
Records received,
Received the paper book.
302. Part Miss S. G. Borua. Learned amicus curiae for the appellant. And Miss V. Bhuya. Learned senior counsel and additional public prosecutor assisted by Miss Lorenzo Das. Learned for the learned counsel for the respondent state. Poster 302. As the case records of Sessions case number 370 within bracket K of 2012 have been received, comma, office to prepare the paper book, release the case after 4 weeks for a report as well as readiness of the paper book. The office to prepare the paper book. If it is done, we can
Yes.
put ahead.
Yes,
It looks like you have a
Yes.
case.
all right.
Item 9.
Not 60 or 60.
Please, my lord. Mr. KP Patel.
Yes.
What is legal at counsel? He is out
Huh?
of station due to his medical checkup, my lord.
Yes,
Sir,
Ms.
please.
Begum.
There is a delay of 27 days. It seems, my lord.
Hmm?
Though POCSO is there, my lord, the punishment is under 376 2F, perhaps.
How much, how much?
Imprisonment for life, my lord.
Live, so
Notice has to be issued, my lord.
not this will. Basically, the condemnation is for the court to decide. It is between the applicant and the court. Inahon একটা কইছিল না will issue notice at the stage of so and so. Inahon আছিল না heard Mr.
Be das, my lord.
Bidas. Learned counsel for the applicant. Inahon একটা কইছিল না তোরা এক করুন। The respond number 2 at the time of hearing the question. Aro Ms. A. Begum, Learned additional public prosecutor for the opposite party number 1, comma state house. The instant interlocutory application is preferred by the applicant seeking condonation of delay of 37 days in preferring the accompanying criminal appeal under section 415 or under section 5 of the limitation act 1963, seeking condonation of delay of 37 days in preferring the connected criminal appeal, accompanying criminal appeal under section 4152 within bracket 2 Bharatiya Nagarik Surakha Act 2023. The criminal appeal is preferred against the judgment and order dated 22/01/2025 passed by the Court of Learned Special Judge within bracket POXO Tinsukia in POXO case number 70 of 2022. Full stop. By the judgment and order dated so and so, comma, the Learned Special Court has Learned Special Court finding the applicant guilty for the offense under section 376 within bracket 2 within bracket small f, comma, Indian Penal Code. Has sentenced him to undergo imprisonment for life and to pay a fine of rupees 10,000, comma, in default of payment of fine, comma. Oh, my. Okay, full stop. Why can you give it will bring cyber. Condon. We have gone through so and so, it will give you. Publish. Yes, madam.
What's your delay?
How many?
I've calculated as 127, registry calculated as 154.
Hmm.
So I have.
Yes, Condon.
POXO lordship.
If you have a good case, otherwise you will be under for 20 years. Hire Miss B. Sharma, Learned Legal Counsel for the applicant. And Miss A. Begum, Learned Additional Public Prosecutor for the opposite party number 1, State of Assam. The instant interlocutory application under section 5 of the Limitation Act 1963 is preferred, seeking continuation of delay of 1 for 54 days in accompanying in preferring the accompanying criminal appeal from jail. Full stop. The applicant as the appellant has preferred the accompanying criminal appeal against a judgment and order. Judgment dated 3/10/2024 and an order on sentence dated 7/10/2024 passed by the Court of Learned Additional Session Judge cum Special Judge POXO Kamrup Metro Guwahati in sessions within brackets special within brackets case number 46 of 2023. By the judgment and order dated by the judgment and order on sentence. The special court has convicted the appellant under both under section 376 AB IPC and under section 6, POXO Act. Post of in view of section 42 POXO Act, the appellant has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 20,000, in default of payment of fine to undergo rigorous imprisonment for another 1 year under section 6 of the POXO Act. Full stop. Para. We have gone through the statements and averments made in the interlocutory application, or more particularly, paragraph 4. There, full stop. From the statements and averments made in paragraph 4, it transpires that the period of delay has occurred in the process of preferring the accompanying criminal appeal by the applicant appellant from jail with the assistance of the learned legal aid counsel. Full stop. Para. As the applicant appellant, we have, having gone through the statements and averments made in paragraph 4, we are of the considered view that the applicant appellant has been able to explain the period of delay of so and so days, 154 days in preferring the, showing sufficient cause in preferring the accompanying criminal appeal. Full stop. Moreover, since the applicant appellant has been sentenced to undergo 20 years. It was okay. Service of notice dispense for applicants. 153 days, 154 days for you. Begum fairly submitted. Interest of justice better self, I will record your submission after effecting service on the victim, so that you were not in. So your submission is that it should be hard after serving notice upon the respondent number 2, right? But we are dismissing your submissions. Okay. How much?
20 years.
Huh?
Delay 2 days.
Oh, 2 days.
2 days. Commission.
Okay.
Delay 2 days, Lordship.
Huh?
2 days only, Lordship.
Only 2 days.
Lordship, that means only.
Parable লিখে দিব? Askenargis applicant. Same thing. Okay. লিখে দিব? Same আগরটন ইসলাম. POCSO case number 232, 2023. Additional session judge comes special judge POCSO Morigaon. Judgment and order dated 4/2/2024. Same 376 AB. Sorry.
6, under 6.
Sentence is under
6.
and conviction both.
Both.
Okay, same. I got to listen. 376 AB IPC section 6.
But in this case, there is no.
412. Judgment is. Conviction is under section 376 as well as under 6 POCSO. And because of section 42, he has been sentenced under section 6 POCSO. Our judgment and order dated 4/12/2024. Period of delay 2 days. Or bagin about submission for again. Oh, paragraph. তাতে প্যারাগ্রাফ কিবা কৈছিল প্যারাগ্রাফ বহুত প্যারাগ্রাফ নালাগে প্যারাগ্রাফ নালাগে ইয়াতে প্যারাগ্রাফ নালাগে প্যারাগ্রাফ নালাগে
Like,
পক্সো
Box
পক্সো
166 this,
your name please
166.
166.
your name is 166
Mr. T Uddin.
TUT applicant Ebegam judgment when order dated 6/9/2024 Court of Special Judge Poxo Kokrajhar special case number 57/2019 এটা খালি only section 4 section 4 POCSO Act section 42 এবার না লাগে 15 years
15 years.
fine 10,000
10,000.
in default of so and so simple imprisonment for another 3 months okay period delay 163 days
Oblate.
Because my inverted mistake, whether I should fine. How much? 2 weeks. AM Ahmed,
Yes.
applicant, appellant. Ms. A. Begum, learned additional public prosecutor for the opposite party number 1, State of Assam, and Mr. T. Chakraborty, learned counsel for the respondent number 2. Informant are present. Mr. Chakraborty, learned counsel for the respondent number 2, as informant has submitted that has sought for further 2 weeks time to submit an objection against the instant interlocutory application filed under section 430 within say BNSS 2000. The appraisal law lays the case after 2 weeks. The respondent number 2 shall ensure filing of its objection on or before that is.
Date may be given will after 2 weeks.
2 weeks, 2 weeks. Yes,
Wait for, I did 14 and 15.
okay. 14 and 15,
14 and then
okay. Who are 14?
it's up to your lordship, we are there, but they
I
are
have
11
raised-
witnesses, right? 11 witnesses.
I have raised a plea of juvenility as per this learned district.
No, which one is to be taken up?
14.
Lordship, if your lordship takes a.
Oh, no, because we have also, I have to sit again in that division means for the first half again tomorrow. Right. These situations and situations are developing also. So we don't know. So. Again, we have fixed the matter tomorrow, already tomorrow. Right? So we'll put it some other day.
Otherwise, Lordship may not take up this matter this as hearing, my lord. Juvenility issue has been raised, my lord. Report has
We'll
come.
pick up for orders, sir, on
So,
Monday.
Lordship may pass, locate order.
Can, okay, we'll put it on, next, you have
Paperwork has been sent.
something already given, something recorded.
Yes. Report has come
Report
regarding
is-
juvenility.
I took time to file
Okay,
objection, but I have not filed my objection yet.
okay,
I may not file it.
okay, we'll put it on the next week then, on a fixed date. Then we'll consider. Thursday, okay, as sought for by Ms. M. Borman, learned legal counsel for the appellant, and Ms. B. Bhuyan, learned additional, senior counsel and additional public prosecutor for the respondent state. Place the case on next Thursday. Thursday.
First time.
Then we'll examine.
She is appearing in the next matter.
Bhuyan, oh, Sharma, okay. It will go thereafter then,
Ninth lordship. Sorry,
not 9th.
10.
After 15, madam. 17th.
Lordship.
Okay. Bishop, outer planet. You are
Legal
legal counsel for the appellant. Abegum. Additional public prosecutor. So this is the case, 17-6. Mr. Doctor, how much time it will take? Because we are also
Not take very
constrained.
long because what has happened my lord, here, there's a 307 my lord. The victim has my lord deposed. There is another eyewitness. And 313 statement he has admitted my lord having hit the person. My lord. Even all the questions he said, yes, it's true, I have hit him, I have hit him. So,
So what is the sentence then?
my lord, life imprisonment my lord, under my lord, 307 my lord. 10 years my lord, under 326 my lord, and 2 years under 324 my lord.
No, 324. 2 years,
One of the
Right
victim of course
for-
was examined.
326.
There are two
10
victims.
years?
10 years. No, my lord, 307 for life my lord.
Oh, where?
My lord,
Come to page paragraph 50.
50 my lord. And imprisonment for life and fine. In default 6, SIF 6,
Sir,
under section 307.
we go simple, and for
Because of the stamp, my lord, it has become a little. PW2 is the victim and PW7 is the eyewitness, my lord. Others all hearsay. They heard about the incident, and then they said they heard some
who
noise.
is the injured?
Injured, my lord, there are two injured. One has not been examined, my lord. The other has been examined.
What is the
on-
reason?
my lord. No, nothing has been mentioned, my lord, why the other person has not
From
been
the
examined.
record,
He sustained some minor injuries for which, my lord, the punishment that has been given, my lord, but then he has not.
Oh, where is the charge sheet? Who, if the two persons are injured, where is the charge sheet?
My lord. Charge sheet is page 62, my lord.
What is the name of the other person?
Other person's name, my lord, is James
Jivon Masi.
Jivon Masi, my lord. Jivon Masi Barla.
Now, is he a listed witness? He is a listed witness.
But it's not, my lord,
Huh.
it's not reduced evidence in the case.
Now, he did not reduce evidence.
No, man.
But conviction and sentence,
Yes. On him also, my lord, because.
for what reason?
My lord, for him, my lord.
I have seen
Yes, my lord.
last sentence.
Yes.
What is the reason? You see, otherwise we have to deal with it.
Yes, my lord, that's to be dealt with. Because in the.
It will come, whether, because if the injured person is available really,
Yes, my lord.
he was a listed witness
Yes.
and he did not come and enter into witness box.
He did not enter into witness box.
Huh?
He did not enter into this.
If I say tomorrow, Mr. X was injured, he is alive, he is working somewhere, but on the basis of my statement before the court, somebody, why will be convicted?
True. True, my lord.
Unless good reason is,
Good reasons.
otherwise you have to deal because he has been sentenced for that also.
That, for that also is message.
Two persons were injured
Yes.
for another sentence has been passed for injuring that injured. Right, the one. And sentence has been passed, paragraph. He is a listed witness, 11. Then why he was not? If he was alive, he did not enter into witness box. Then for what reason? Conviction.
For, I think Divan Masi Parla, yes, sentence.
No, I'm not on that. I am saying in one incident, two persons were injured. One is one is what?
Santok, my lord.
Sayanda.
Sayan, my lord.
Sayanda, okay. The other is Zibon.
Sayanda.
Now, if you see the Sarsit, page 62, if you see the listed witnesses by the prosecution at serial number 9, Zibon Masi. And serial number 8, Sayanda. Both the injured, right? Now you see the index of this paper book. Zibon is not there. Now come to paragraph 50 of the judgment. This appellant has been convicted under section 324 IPC and sentenced of rigorous imprisonment for 2 years by voluntarily causing hurt by a dog to Zibon Masi, right? 324 means simple hurt. So, unless he is not alive, Zibon should have come. If alive and did not come, there must be some reason. Otherwise, why he should be convicted for that?
That 2 years.
Unless good and sufficient reason. He should have, because he is not dead till the submission of Sarsit, say. But it must be something somewhere. You have to go through it.
Right.
Otherwise, this part is also bad.
Because in fact, the other victim, he did not say that he saw him being hit. He said, I saw him injured in the forehead. And PW7
No,
is the only person who says that.
unless you go through the records, you
Records,
have to find the answer.
Why he was not examined.
Otherwise, in respect of other victim, that is.
The difficulty is on us. You can go on making submission.
But she was to the side. Why?
Doesn't seem.
You better see, otherwise it will be difficult. Because two injured. Yes. So he was under section 324. Meaning there was simple heart.
Yes.
Quite clear.
Ma'am.
Only heart, not previous heart. So he was otherwise normal presumption is that he is quite okay to depose. Why he did not depose? If he did not depose, the vital witness is not
Yes.
examined. That goes. But to write that part, we need the answer. Otherwise, you have eyewitness.
Yes.
313 you have admitted.
He has admitted. 330, all
But
the
that
state,
part we have to deal with. We find otherwise.
all the statements he said, yes, I have hit, I have hit. Yes, of course, tried to explain why he has hit, but that is not under the grave and sudden provocation, but he said that this person was.
Okay, you go through it tomorrow, that case, take up this case also. We'll take up this case also.
That case, it will not take much time. So it has-
After hearing you, we may do it CV also.
Yes,
But think it over. Think it over. So we can put it this one. But in the second half only, I'll be busy in the first half.
well, understand, right?
We'll just find out the answer. I'll give you. Let's just appeal tomorrow. I am Dr. Amicus Curie, our also learned public prosecutor for the response team. In the meantime, we'll go through it also. 313, if it is admitted, whatever.
The only difficulty is tomorrow will not. Hearing us. The only difficult tomorrow will perhaps second half, there are two more hearings which were likely to be taken in the second half. None of the division bench.
Okay, then, we'll hear the
Day after tomorrow.
15-20 minutes. No, my esteemed sister will be out again. Composition of.
Well, I'll try, if there's some difficulty, I'll.
Okay.
Otherwise I'll try.